Hello, you're watching Addleshaw Goddard's Employment Channel news programme on the 19th of December. ACAS has this month issued guidance for employers on workplace issues over the winter months, and we take a look at this in today's news programme. We'll also look at a recent High Court case reminding employers of the extent to which they can impose confidentiality provisions on former employees. And finally, a recent case dealing with the concept of marriage discrimination. You'll be well aware that winter often brings its own set of workplace issues, such as adverse weather conditions leading to staff shortages due to travel disruption, seasonal celebrations resulting in a rush to book annual leave, and the occasional drunken incident at a staff party. ACAS has recently published top tips for employers dealing with common issues that arise at this time of year. And you can access this by clicking on the link below the screen. The overall message is clear: to plan in advance and have clear policies around these types of issues that are communicated to staff well in advance. Lena Amati, a barrister at 9 St John Street Chambers, discusses some of the key issues and how to deal with them in practice.
The ACAS guide on winter workplace issues contains useful pointers and good practice when dealing with travel disruptions, sickness absence, holiday requests and workplace well-being. Whilst the guide isn't legally binding, any policy which is challenged in tribunal proceedings will certainly be strengthened if drafted in compliance or with regard to the guide. Adverse weather cost UK businesses millions of pounds last winter, and this year, in order to avoid workplace disputes and ensure efficiency in your business, it is essential to have a policy which is consistent and is communicated to staff as early as possible. One of the biggest challenges faced as a result of adverse weather conditions is productivity and how to deal with pay on days where employees are not able to travel to work. Employees are not automatically entitled to pay if unable to attend work due to bad weather. If there is a custom and practice within your business, efforts should be made to ensure that it is applied consistently and staff are informed. Employers will do well to consider whether their employees are able to work from home. For those companies which have remote access to their IT systems, it may be useful to ensure that employees are aware of how to utilise those facilities and are reminded of confidentiality and IT policies in place. Another issue which employers face during this season is increased sickness absence. Employees should be reminded of the sickness absence reporting procedures, including the short-term absence reporting procedure. Furthermore, employees should be reminded of the consequences of failure to comply with the sickness absence reporting procedure. One would hope that employees have already requested and dealt with their holiday over the Christmas period. However, employers are reminded that when public holidays fall on Saturdays and Sundays, alternative weekdays are declared public holidays. There is no legal right to be paid leave for public holidays. Any right to paid time off for these holidays depends on the terms of an employee's contract. Finally, the guide reminds employers of the importance of looking for signs of stress and/or depression in the workplace. It emphasises that spotting and doing something about troubled employees is an important business skill, and employers should make sure that managers know how to respond to signs of stress.
Thanks, Lena. Moving on now, we have a High Court case this week which serves as a helpful reminder for employers of the extent to which they can impose confidentiality provisions on former employees. This is an interesting case in the current climate, given that many employers in our experience are witnessing a fairly high turnover of employees. In this case, the High Court declined to order an injunction to restrain a former employee from using or disclosing confidential information, despite the existence of a confidentiality agreement. It reminds us of the leading case law on the issue of confidential information and the key principles on this topic that have emerged over time. Again, Lena discusses the facts of the case in more detail and the key learning points for employers.
The facts of the case are fairly commonplace. The High Court considered applications by Caterpillar Logistics for an injunction restraining a former employee from using confidential information in her employment with a main customer. Here, Mrs H was employed by Caterpillar Logistics as a middle-level manager. Her contract contained no restricted covenants, but she did sign a confidentiality agreement which provided that she will not use any trade secrets or confidential information for herself or others, or divulge them to others during or after her employment. The terms trade secrets and confidential information were specifically defined. When Mrs. H resigned and joined a client, Caterpillar Logistics wrote to her saying that it was likely, if not inevitable, that she would use or disclose its confidential information in her new role, and so it sought wide undertakings which she refused to provide. Caterpillar Logistics applied for an injunction restraining her from using or disclosing confidential information, which had no limit in time. It also applied for a barring order, prohibiting Mrs. H from being involved with the commercial relationship between Caterpillar Logistics and her new employer. The High Court declined to grant the injunction or barring order. In terms of the confidentiality injunction, the High Court said that the confidentiality agreement was too wide to be enforceable. It referred to competitors of Caterpillar Logistics, and Mrs. H's new employer was a customer rather than a competitor. It included matters which were not trade secrets, and Caterpillar Logistics had not told her to treat the information as confidential during the course of her employment with them. Also, the form of the injunction was too wide, as there was no time limit, and it didn't make it clear what Caterpillar Logistics was seeking to protect. In terms of the barring order, it's not surprising that the court wasn't willing to grant what is a very wide form of order, as it would have been a significant extension of current case law. It recognised that Mrs. H had been a lawyer employee who had offered undertakings which she could be expected to fulfil, and a barring order would be a disproportionate remedy in view of the perceived threat. The decision highlights the importance of identifying confidential information during employment and being specific about what the employer needs to protect when seeking an injunction, which in practice can often be extremely difficult to obtain. The decision also refers to a useful list of principles relating to confidentiality obligations on former employees, which any employer considering obtaining an injunction against a former employee should be aware of. The key principles being that where an employer is seeking to protect confidential information by an injunction, it must make it absolutely clear what it is seeking to protect. Specific lists and sources of information are required, and a lack of particularity may prove fatal to an application. An injunction will not extend beyond the period during which the information remains confidential or for which any unfair advantage may be expected to continue. Any relief granted by the courts must be no more than is proportionate to the threat of the legitimate interests of the former employer. Where the nature of the information that employers wish to remain confidential is unlikely to be specific enough to warrant an injunction, emphasis may turn to provisions of guarding leave as a means of protection.
Thanks, Lena. And finally, the Employment Appeal Tribunal has provided a useful reminder for employers that it's unlawful discrimination for an employer to treat an employee less favourably on the grounds of his or her marital status. It also goes one step further and confirms that it will be unlawful to treat an employee less favourably because they are married to a particular person. Here, Mrs. Dunn complained that she was being discriminated on the grounds of her marital status, as she was married to Mr. Dunn, who worked for the same employer and with whom it was also in dispute with. So, all in all, a reminder for employers to check their discrimination policies and training material to include reference to this fairly rare but nevertheless important strand of discrimination. So, that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.